Moore versus Harper comes to argument. Good afternoon, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Holm. Yes, election law, as applicable to elections of representatives in Congress, came before the United States Supreme Court yesterday. The court heard argument on this one case for nearly 3 hours. Today, I conclude that lawyers for the North Carolina House of Representatives did not prepare adequately to argue for the sweeping change in election law that they sought, which was to cut the courts of North Carolina out of the process of drawing congressional district maps. Furthermore, the only reason we are at this pass is a set of precedents that make a mockery of federalism. Counsel for petitioners could and should have challenged the entire framework. They did not, and for that reason, I think they're going to lose. Before I tell you how and why, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views, link in the description. And be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, including this t-shirt that I have chosen for today, which reads, "Freedom isn't free." And it's going to take a lot of remedial civics education for us to keep what freedom we have, what we still have, and to take back what we have lost. One more thing. If you like what you're about to hear, you can like this video. You can also click on the bell icon to get a notice every time I come out with a new one. In fact, you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click on that and leave me a tip. Any currency will do, so long as it's legal tender. Now, the case at hand is called Moore versus Harper. That's docket number 21-1271. Reportage on the argument session comes from CBS News and Politico, with a live blog from a site called Democracy Docket. In addition, readers can play the MP3 recording of the session directly or read the transcript. I've left links in the description to the docket page, the MP3, and the transcript. The case is a petition for review of a decision by the North Carolina Supreme Court. After the 2020 census, North Carolina's Republican-dominated legislature drew a map favorable to their party. Several plaintiffs, including Common Cause, challenged the map as an unlawful partisan gerrymander. Of course, I've never heard of them doing that for Democrats. The North Carolina Supreme Court, applying North Carolina law, agreed and has struck down the maps. So Representative Tim Moore, Republican from Cleveland and Rutherford counties, who, more to the point, is Speaker of the North Carolina House, petitioned the Supreme Court for review. In fact, yesterday afternoon, Moore stood on the courthouse steps and he tweeted his reasoning for asking for the review. I have a link in the description, link to that tweet in the description. I will now quote the text. "This case is about one thing. Who decides the inherently political question of how a state's congressional districts should be drawn? The people's elected representatives in the legislature or activist judges?" Unquote, Tim Moore. The activist judges accusation comes from the definitely woke politics the North Carolina Supreme Court has shown thus far. In fact, furious North Carolina voters flipped the court when 2 Democratic justices failed a re-election last midterms. One of them was Justice Samuel J. Ervin IV. Yes, he's one of those Ervins. His grandfather was the witty chairman of the Senate Watergate Committee. Maybe most of you don't remember, but I do. I remember sitting in front of an old cathode ray color TV set listening to one of the Cuban exile witnesses before the committee who had taken part in the burglary at the Watergate Hotel. So Senator Ervin asked, and I quote, "How did you expect to liberate Cuba by perpetrating a burglary in Washington, D.C.? I mean, he brought the house down. Anyway, his grandson just got thrown off the bench together with another Democratic justice. The thing is, it's too late to get a reversal on the case at hand in North Carolina court level. So that won't help the Republicans press their advantage in redistricting. So Tim Moore filed this petition for review as a Hail Mary pass. He filed this petition to invoke the independent state legislature theory. According to it, the Constitution vests in state legislatures only the power to draw congressional districts. This also includes the power to set laws qualifying voters for representatives and senators. You remember I discussed this before, last July. Briefly, the Constitution, Article 1, Section 4, Clause 1, says that legislatures will prescribe the time, place, and manner of holding elections for senators and representatives. Legislatures, it says, not the courts. The Constitution said nothing about a legislature prescribing by law, but the Supreme Court held in 1932 that redistricting is a law-making function. Therefore, at minimum, state governors have their usual veto powers, as on other bills. Smiley versus Holm, 285 U.S. 355, 1932. I have a link to that case in the description. That holding speaks directly to what a legislature is and what powers a governor has over the legislative process. It does not, however, explicitly provide for state judicial review of a district map. More recently, the Supreme Court has held that whenever a state constitution vests redistricting power in an independent commission, such commission is a legislature within the meaning of the U.S. Constitution. Therefore, the federal Constitution cannot override this. Arizona State Legislature versus Arizona Independent Redistricting Commission in 2015. And I have a link to that case in the description also, same as Smiley versus Holm. Now, this case concerns a legislature within the usual meaning. The governor did not veto the original map, so Tim Moore decided not to make an issue of veto power. But as a further complication, the Supreme Court of the U.S. has already said it will never again hear a partisan gerrymander case. Rucho versus Common Cause, 2019. Right about now, I hear some of you asking, how do you measure partisan gerrymandering? I want to take a little extra time to explain that because the court brought it up and it illustrates the silliness of where we are and the pressing need to find another way to solve the problem of districts coming out looking like somebody's pocket comb or the letter Y or this, that, and the other. Before I begin, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You're not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of others, of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, either way, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. Okay. In an article in the University of Chicago Law Review, Nicholas Stephanopoulos and Eric McGee proposed a measure they call the efficiency gap to measure partisan gerrymandering. Efficiency in this context means not only winning, but winning with as few votes as a party needs. Typically, this applies only to a two-party election in a single-member district. The losing party loses all votes cast for it. Contrariwise, the winning party exceeds necessary votes when it wins by more than 50% plus one vote. Any party wastes votes that they either lose or by which they exceed the magic number. The efficiency gap is the sum of differences as absolute values between lost votes, the loser, and excess votes, the winner, over all districts in a state as a fraction of all votes cast. The absolute value of any number is that number with any minus sign stripped away. Thus, the absolute value of, say, 1 is 1. And the absolute value of minus 1 is also 1, because it is 1 away from 0, and it doesn't matter which side of 0 it's on. So the absolute value of the difference between two numbers is how far apart they are, without regard to which number is greater than the other before you subtract one from the other. So, to calculate the efficiency gap, first you determine the wasted votes for each party. So in each district, if the party lost, count every vote it got as wasted. And if it won, count every vote past 50% plus 1 as wasted. Then you sum all those up across all districts for each party. Then you subtract the wasted votes by one party from the wasted votes by the other party. And again, make sure to subtract the lesser from the greater because you want the absolute value. Then you divide by the total across all districts and multiply by 100%. I have this from Ballotpedia. That number is the efficiency gap. I have this from Ballotpedia. I have the link in the description of that too. The highest possible efficiency gap is 50%. Winner takes all votes by 50% plus 1, and the loser wastes every vote cast for it. Now, in theory, one could achieve balanced efficiency, meaning winners exceed their necessary votes by the same amount that losers waste. That requires winners to take their seats by an average of 75%. Winner wastes 25% of their votes over 50% plus 1. Loser wastes 25%, so they're even. And if a party carries every district with 100% of the vote, the efficiency gap rises to 50% again. Now, do you see the problems in efficiency gap thinking? The only way to minimize the efficiency gap is to create safe districts everywhere. Furthermore, the ideal ratio of voters in any district is 3-to-1 for the winner. So the parties might as well nominate only in their safe districts, and no districts will ever be competitive. Result, uncontested elections. And I count empty suits as no contest at all. And the districts will then take on even wilder shapes than they do now, as they did in order to carve out safe minority districts that followed interstate highways or railroad tracks. Well, if the legislature is going to do things that way, they might as well elect all representatives at large by proportional representation, the way they do in Israel. The state holds an election, determines a total popular vote distribution between parties. Then the Secretary of State awards mandates or slots to each party in proportion to the popular vote that they got. Where then is the accountability that democratic elections are supposed to provide? What they should do is make certain rules for legislative or congressional redistricting. How about forbidding a district boundary to cross a county line or a city or town limit or a city ward line? How about not splitting a county or independent city between or among 2 or more districts unless each district in the split is a part of that county or independent city? Ideally, each county or independent city should also get the same number of state senators, either 1 or 2, but apparently the Supreme Court has said no to that also. This one person, one vote thing. That is an unhealthy obsession. Tim Moore could and should have challenged that. Sadly, he did not. Instead, Moore, or rather David Thompson, his attorney, tried to argue that although governors have a role, courts do not. In this, he drew inspiration from Chief Justice William Rehnquist's concurrence in Bush versus Gore, 531 U.S. 98,113, 2000. That case involved presidential electors, another question the Constitution gives to legislatures to answer. Rehnquist wrote, and Justices Antonin Scalia and Clarence Thomas agreed with him, that, and I quote, a significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question, unquote, William Rehnquist. As seems to be his pattern, Justice Thomas opened by asking Mr. Thompson to state clearly the court's jurisdiction in the case. He did. And naturally, Mr. Thompson cited the Elections Clause of the Constitution. Soon afterward, and this did not change throughout the argument session, 3 blocks of justices sorted themselves out. Justices Ketanji Brown Jackson, Elena Kagan, and Sonia Sotomayor were uniformly hostile to the petitioner and sympathetic to the election case of the respondents, and to Solicitor General Elizabeth Prelugar, arguing as friend of the court. Let's call them the liberal bloc. Justices Thomas, Samuel A. Alito, and Neil Gorsuch likewise proved sympathetic to the petitioners. Call them the conservative bloc. The bloc of Chief Justice John Roberts and Justices Amy Coney Barrett and Brett Kavanaugh became the neutral bloc. All 3 members of it asked the hardest questions of petitioner and respondent alike, as a side alike. Well, Tim Moore should have known how high a bar over which he was trying to vault. As the liberal and neutral blocs made absolutely clear, he is trying to override 233 years of history. The independent state legislature theory finds some support in Bush versus Gore, but in a concurrence only, not the opinion of the court. And of the 3 concurring justices, only Clarence Thomas remains, although Alito and Gorsuch do seem to sympathize with him. On the other hand, the 2 lawyers for the respondents and the Solicitor General seem to be trying to present a case of res ipsa loquitur. Now that's Latin for the thing speaks for itself, saying, hey, this is obvious. They also said that chaos would reign if the court finds for more. The only practical result of this chaos that they could allege is that state legislatures could draw districts however they wanted. What they really mean is that they, respondents and the Solicitor General, would lose all the ground they have carefully gained toward their true goal, proportional representation by color, race, creed, lifestyle, whatever. The justices seem to know this. Chief Justice Roberts trapped Thompson into expressing willingness to accept a rule limiting the efficiency gap to 7%. Now you know why I took extra time to explain what an efficiency gap is. But when he did that, Roberts exposed the most glaring weakness in the respondent's case. No firm rules exist. The North Carolina Supreme Court simply made their determination and they had no firm theory to back that up. About halfway through my research into this case, I found myself asking myself, how did we get here? Well, here's how. The Supreme Court is hearing this momentous election case because Brett Kavanaugh looked at the prior election jurisprudence and quailed. This is going to crop up again and again until we finally settle it, he said in effect. Enough! Let's grant cert in this case or a similar one, set a precedent, and have done with it. So we can guess which 4 justices, at least, voted to grant cert review in Moore versus Harper. Thomas, Alito, Gorsuch, Kavanaugh. And when he briefed the court, Moore's lawyer, Mr. Thompson, made key mistakes. He could and should have seized upon the absence of the key phrase by law in the Elections Clause and the Presidential Electors Clause. Justice Alito has already said in Dobbs v. Jackson Women's that stare decisis is not a hard and fast principle anymore. So if cases like Smiley or Arizona need relitigating, by all means, let's relitigate them. And if Thomas Dobbs had made the kind of mistake that Mr. Thompson made, he would not have achieved the result we all know. But the Mississippi Solicitor General boldly decided to relitigate Roe versus Wade, and he won the grand prize. But many other precedents need relitigating. All the litigation on gerrymandering has assumed that 1, political parties are legitimate, and 2, proportional representation between and among them is only fair. Both are wrong. Both need a challenge. You go look on Conservative News and Views. Search for an author named Bradley Dean, and he'll give you an eyeful. He'll tell you that political parties have no place in the Constitution. This case is a missed opportunity. And though the neutral bloc asked equally hard questions of both sides, in the end, I think they're going to fine for the respondents. Most probably, unless Clarence Thomas can get to work on them. Now that the case is officially submitted, he has half a year to make that happen. Link in the description to the article, to the docket, sound recording, and transcript for Moore versus Harper, to Tim Moore's tweet from the Supreme Courthouse steps, to the cases of Smiley versus Holm, Arizona Legislature versus Arizona Commission, and Rucho versus Common Cause, to Ballotpedia's explanation of the concept efficiency gap, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to oursilverlines.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to my channel and a link to an earlier video from July on this case. This is Terry A. Hurlbut delivering another Declaration of Truth and reminding you to let the truth set you free.